Hello. We will find that out in the.
A lot of them on there. Come on, man.
All right, we're gonna go on the record. Next matter coming before the court is Lincoln County Cause CV 2026-191. Samuel Valeriano, Raymond Valerio, and Manuel Garcia petitioners versus New Mexico Racing Commission and the Board of Stewards of Rio Downs. Nelly Valencia appears on behalf of the petitioners. Richard Bustamante appears on behalf of respondent New Mexico Racing Commission. I think it makes logical sense to deal with the petitioner's emergency verified motion for a temporary restraining order permitting the entry and participation of the 11 horses at the trials on August 7th and 8th, and then move to the show cause hearing. So we'll start with that petition first. I'm not going to take evidence on that. We'll just share the legal argument and then I'll make a decision. Ms. Valencia, you can go first.
Your Honor, can I have just a few moments to get settled in?
Sure. Mr. Bustamante is also asking for a request. You're muted, Mr. Bustamante. I can't hear you.
Judge, one preliminary matter, and as an officer of the court, I feel compelled to bring this to the court's attention and just ensure that something untoward doesn't happen. Yesterday, we had the 3 summary suspension hearings for the 3 petitioners. During the last summary suspension hearing, I and a few other members of the office heard a male voice basically advising Ms. Valencia of what to ask, and she in turn asked the exact same question that we heard a male voice advising her to ask. The reason I bring that up, sir, is that I noticed that one of the persons that signed on, and I apologize, Mr. Chavez, but is Gene Chavez. And as far as I know, Mr. Chavez's law license is suspended. I don't know if that's still the case, but I just want to make sure that nothing untoward like that happens where perhaps Mr. Chavez, if he is still suspended, was the individual that we clearly heard providing the questions to Ms. Valencia, which she in turn asked at the summary suspension hearing. As an officer of the court, I feel compelled to bring that to the court's attention. Thank you, Judge.
All right. Ms. Valencia will come on camera. I'll have her come on camera. What I'll say is, obviously, Mr. Chavez is on the Google Meet. It's a public hearing. He's allowed to be on the Google Meet.
Correct.
Exclude him. He's not permitted to practice law in the state of New Mexico currently, and if he attempts to practice law, then he might end up with another referral that might lead to a disbarment instead of a suspension. And so I think that Mr. Chavez is well aware of that, and so he'll probably be cautious to not do that. So, Ms. Valencia, let's start with your emergency verified motion for temporary restraining order.
Yes, Your Honor, one moment. Let me pull up my notes.
I guess, Ms. Valencia, since Mr.
Yes.
Bustamante's put it on the record, I'm going to ask as an officer of the court, is Mr. Chavez currently present in the same location as where you're located?
Yes, Your Honor.
All right. Then what I'm going to ask is that Mr. Chavez needs to remove himself from the same area where you are located. You all need to be in separate rooms and he can't participate in these proceedings.
Yes, Your Honor. I understand. There's no problem with that.
All right. So do you need a minute while that happens?
Your Honor, I'd also like to note that Mr. Valeriano and Mr. Valerio are also in the same location that I am. Oh, I'm sorry. Sorry, not Mr. Valerio.
Your client can be with you. That's fine.
Yes, and that's some of the feedback that we were hearing.
And you can consult with your client, but I need to make sure that you as an officer of the court are verifying that Mr. Chavez is out of the room. So when he's out of the room and you all can no longer communicate, then you need to let me know that.
Yes, Your Honor, no problem. Yes, that's been done. And if you just give me just a moment to fix Mr. Valeriano's computer so that we don't have that feedback.
Yes, sir. Yes, ma'am.
And thank you, Judge.
I apologize, Your Honor. We were just working out the logistics of that.
Go ahead.
Okay, thank you. Your Honor, before the four factors, let me say that with this motion does not ask for because the respondent's response answers a motion I did not file. I'm not asking the court to reopen entries. I am not asking that a race be added. I am not asking that any race be delayed or that any published condition be changed or that any other owner's horse be scratched, moved, or repositioned. I'm asking the court to order the Downs at Albuquerque or Ruidoso Downs to do anything, and neither is a party. I'm asking the court to order the commission, which is a party, which has appeared and which is before the court, to remove any impediment the commission itself created and to say in writing to the racing office that it does not object and it will not discipline anyone for accepting these horses. That is all. The substantial likelihood of success, the commission is placed these 11 horses on the steward's list. Ruling 103 says so. 2 days later, it removed 5 of them by name expressly because the court's order named them. Ruling 104 CC on August 2nd and ruling 104 again yesterday. The sole reason the entries were refused on July 31st per respondent's own affidavit at paragraph 13 was that Mr. Valerio was suspended. That suspension was dismissed yesterday on the commission's own investigator's recommendation. The predicate is gone and the commission has already demonstrated the mechanism twice. The irreparable injury is these are 2-year-old horses. The All-American Futurity has 1 eligibility year. A horse that does not start in the trials cannot run and in the final and cannot come back next year. There is no damages remedy, and against this respondent, there is likely no damages remedy at all. The injury is complete at post time tomorrow. Under the order, I'm asking for Mr. Valeriano, as he remains summarily suspended, he remains excluded from all commission grounds. He may not set foot on the racetrack. Rulings 103 and 105 stand unreviewed and unstayed. The stewards list stands. Every remedy the commission has, it keeps. What it is asked to do is send a letter. The horses remain subject in every respect to a pre-race examination and post-race testing. The stewards retain the authority to scratch under 15.2.5.9. If a horse comes back positive, the commission has its ordinary and complete remedy. Testing is the integrity safeguard, and this motion does not touch it, and no other horseman is displaced. I'm asking only for the positions already vacant. I accept that this is an affirmative relief and that under Lujan Grisham v. Romero 2021, an NMRC 009, paragraph 20, I must show the 4 factors weigh heavily and compellingly. I accept that burden on this record. The commission lacks authority because they placed the horses on the list and took 5 off. Ruling 103 and 104 both issued yesterday. The That is the authority exercised twice this week in writing. The next element is the necessary parties are the racetracks. We have consented in writing to joining both tracks and will file an amended petition and serve them today. However the court directs. If the court thinks that they are necessary, order it. I ask only that the interim relief issue so the horses are not lost while the pleadings catch up. The horses were never entered and the fields are set. They were never entered because the commission refused entry and for a single reason that Mr. Valerio was suspended, and that suspension has been dismissed. As for the fields being final, horses that were scratched from the very trials this week by the stewards under their sole authority in 15.2.5.9. The owner's suspension disqualifies the horses. In the response, he says he is in effect disqualified. In effect is doing all the work. 15.2.5.12 turns on a disqualified person, and that term is not defined anywhere in Title 15, Chapter 2. And on August 2nd, the commission let 5 of the horses enter while he was suspended. The petitioners want an exception from the rules. I'm asking for the opposite. In their own cases, an agency is bound by its regulations, and in Yoakum, the Court of Appeals voided a suspension because the commission did not follow its own rule. I'm asking that the commission rules be applied, including 15.2.1.9 A7E, which requires that a licensee be told of his right to appeal and which rulings 103 and 105 omit while ruling 104 contains in full effect. I asked the court for an order directing the commission to notify the racing office of the Downs at Albuquerque in writing and before racing tomorrow that it does not object to the entry and participation of the 6 horses named in the first sentence of paragraph B, and that it will take no disciplinary action against any racing official for accepting them, and directing that those horses be placed in positions available by reason of scratches with no other owner's horse moved. Today's races I recognize are gone. I am asking for tomorrow.
Anything further, Ms. Valencia?
Nothing further at the moment, Your Honor.
Mr. Bustamante?
Good afternoon, Judge, and may it please the court. Judge, first of all, I will call the court's attention to the title of the latest TRO refers to seeking a temporary restraining order permitting the entry and participation of 11 horses in the trials of August 7th and 8th of 2026. Essentially,
We're talking about 6 horses, basically.
Okay. All right. Thank you, sir. First of all, judges, with respect to petitioner's request seeking an order requiring the commission to lift the summary suspension off of petitioner Valeriano's license. First of all, let me advise that the reason the stewards lifted the summary suspension with respect to petitioner trainer Valerio is in order to allow the horses that will be running in the 2 races in which he successfully entered on Sunday, August 2nd, to allow them to basically have a trainer that would basically be responsible for the care, custody, and control of those horses till this time, up until those finals are run. So that was the reason why basically that summary suspension was lifted on the trainer. There is a rule that says once the entries are done, then the owner is not permitted to change trainers. So that explains the rationale behind the stewards lifting the summary suspension on the trainer, such that he could be in the care, custody, control of those horses, both as they prepare for the trials and they run those trials.
Let me ask you this, Mr.
Yes, sir.
Are those 5 horses even eligible to run now that their owner has been suspended and had a due process hearing? Or are they going to get scratched?
Well, Judge, as I mentioned to you yesterday, as an officer of the court in full candor, A summary suspension impacts an owner and trainer's license in two respects: the ability to enter and the ability to run. If the summary suspension remains on owner Valeriano, that does impact the ability of his horses to run in the All-American Derby trials and the All-American Oaks. Now, with respect to, assuming for argument's sake that the court orders the commission to lift the summary suspension status on the owner Valeriano, well, Judge, with all due respect, that absolutely impacts in no way, shape, or form his efforts to try to run the 6 horses in the final trials that are happening tomorrow for the All-American Futurity. And the reason for that, Judge, is because although the summary suspension will be lifted, again, those horses were never entered into the race because at the time those entries opened and closed, he was under summary suspension as well as the trainer, and those entries opened and closed prior to the time that the court issued its temporary restraining order. As we mentioned yesterday, and will provide further argument on the order to show cause, there are simply no rules or authority which allows the commission to basically either order the track to add a new race or to put in horses if there's some scratches, and there's no authority for the commission to basically order the racing office to open up those entries, which have been closed now for a week today, just to basically provide those the horses the ability to enter, and then either create a new race for them or fit them in if there's enough room for scratches. The other problem with that, Judge, is that, as I mentioned to you, once those entries are closed, the racing office immediately starts to basically set the fields for the trials. Once those fields are set, those are finalized, and that information is disseminated. For example, today, the first day of the All-American Futurity trials started. They continue and end tomorrow. And of course, all those racing fans and wagers have the access to the program, which basically lists every single horse that is in every single one of those trials, along with a lot of information that informs the wagerers. At this late stage in the game, Judge, that would really be detrimental to the wagering public and to the fans of the sport, because essentially it upends the entire, basically, finals for the All-American trial. So again, Judge, with all due respect, lifting the summary suspension on owner Valeriano will allow him to run and enter in the All-American Derby and the All-American Oaks, but that does nothing to impact the ability of his horses to be entered and run in the All-American Futurity trials, which again have already been set, are in process as we speak, and will be concluding tomorrow. So essentially, Judge, we're in another situation where because of the authority of the commission that it does and doesn't have, essentially, it's a factual impossibility for this to happen. Additionally, the tracks were never made parties to this action. And as we mentioned yesterday, it is the tracks, specifically the racing office, that really control every aspect of these entries in terms of when they set them, when they close, when they communicate and disseminate the information on the final fields. So essentially,
I mean,
I'm sorry,
to a certain extent, but I mean, this race can't happen unless the commission says it can happen. That's what 60-1A-4 and 60-1A-5 both stay, in that the commission has the authority. For instance, I guess technically, I'm not saying I'm even remotely thinking about this, but I could enjoin the entire races from happening tomorrow, couldn't I?
you know,
Because I can give you an injunction that requires you to cancel all races. and you'd have to comply with that. And then the Downs couldn't race without your permission.
Well, Judge, let's just say that is a unique issue, and I'm trying to think right now about whether, obviously you could do that.
I'm not saying I'm going to. I'm just saying, under your hypothetical, it's as if you have no control over these entities. You do. You got a lot of control because you can shut the race down like that. The commission today could stop racing tomorrow if it deemed it necessary. For any reason, for any qualified reason.
That would be, Judge, that would be an extreme and drastic remedy. And for example, the only—
I'm not saying I'm going to do that. I'm just saying, like, let's use a hypothetical that has nothing to do with the court proceeding.
Right.
If there was some sort of infectious disease found with one of the horses, you could shut the entire racetrack down tomorrow if you felt like it was needed to protect the industry and protect the horses. So you have that authority to shut these races. They don't run independent of the commission.
And Judge, I'm glad you provided that example, because it is an extreme example like that. And I think the term we utilize is acts of God or acts of nature. Clearly, Judge, if the commission learned of a outbreak of equine infectious anemia, clearly for the safety of the horses, the commission could step in and say, we need to cancel racing altogether. Everybody, please get your horses off the grounds and have them tested for EIA. Another example would be, for example,
flooding in Ruidoso when horses are actually floating down the road because the track has been.
And Judge,
flooded.
that you anticipated my second example, when there would be a natural disaster like a extreme flood or a forest fire that endangers not only the patrons and the licensees on the racetrack, but the horses. Clearly, the commission could step in and say, for the public safety, we could do that. Judge, with all due respect.
I'm not saying I'm going to, Mr. Bustamante. I'm just saying that the argument that these entities aren't under your purview, I'm not buying that part, I guess. I think that they can't operate without the Racing Commission, and therefore the Racing Commission can force them to do what the Racing Commission wants them to do.
And Judge, in the general concept, you are correct. But I would respectfully submit that Mr. Valeriano's situation in no way, shape, or form arises to the level of an extreme situation where the court would feel that it needs to force the commission to stop all races, or that the commission on its own would basically stop all races simply to allow this individual to enter races, which are the trials of which are already running as we speak. Judge, earlier you did make reference to a specific part of the Horse Racing Act. I think you mentioned 60-1A-4B, which talks about the commission does have the authority to identify and assign race dates. Judge, what that refers to basically is every single year, all the racetracks have to reapply for licensure. Part of that licensure is requesting specific race dates for the next year, and that is what that authority refers to. The commission takes all of those requested race dates, and then they look at the calendar for the next year, and they assign the race meets, attempting to prevent as little overlap as possible between race meets. So that is what that authority deals with. That is the overall picture of what is the race calendar for New Mexico going to look like for 2027 or 2028.
But the commission also has authority over the license of the track.
That is part of the licensing application, sir.
Right. So that also controls more than just setting race dates. You could summarily suspend a track, could you not?
Judge, basically, any licensee is subject to the same types of disciplinary action that an individual licensee is. So the answer is yes. A track license could be summarily suspended. They could be subject to disciplinary proceedings, just like an individual licensee or a business entity that is licensed by the commission because it does business with the horse racing industry.
And
But again,
getting to the administrative code, 15.2.1.8B1, the commission shall regulate each race meeting and the persons who participate in each race meeting, seems to suggest that you certainly have the authority to regulate who participates in races as well.
and Judge, just like the racetracks have to apply for licensure every year, essentially all of our licensees, whether they be individuals or businesses, do need to apply for licensure. Depending on the type of license, it can either last 1 year or 3 years. But that rule does talk about the ability to, each one of those entities has to file an initial application if it's the first time being licensed. There's a background check. They have to provide fingerprints and complete an application. They may have to undergo questioning by the stewards, perhaps maybe take a trainer's test. And then essentially, once their license comes up for renewal, they basically have to renew the license. And depending on their past history with that license, past disciplinary matters, or for example, if their fingerprints have expired, they will be subjected again to another background examination by submitting fingerprints. But again, Judge, that is basically the idea and the statutory mandate that the commission is responsible for the licensing of every single individual and entity that participates in the horse racing industry. But again, Judge, those authorities should not be read to mean that that the commission can step in and order a track, reopen those entries to allow somebody to enter, or set another race to allow those new entries to run. The commission respectfully does not believe that authority extends that far. And the reason for that is because these are obviously private businesses. They do undergo public regulation, commission on the racing side, gaming control on the gaming side. However, they do and are allowed to make business decisions, basically, that the commission, either by rule or by practice, essentially does not feel that it's part of their regulatory duty to look into, dictate, change, or otherwise manage. And the setting of times for entries, opening and closing times, and things of that nature are matters that the commission has long considered business decisions by the court, by those private businesses, of which the commission is loath to get involved in and does not. Typically, the biggest issue when the commission is considering the condition book, it's called, is they will ask of the tracks, how many opportunities for thoroughbreds are you proposing to give in your race meet next year? How many racing opportunities for quarter horses? So that's about as far as the commission will go to basically dictate or regulate what it believes are individual business decisions in terms of opening and closing of entry periods for races, as well as how and when they schedule trials or finals.
All right, thank you, Mr. Bustamante. Anything else you want to put on the record?
I'm sorry, sir?
Anything else you want to put on the record?
You know, basically, I just want to say, Judge, that with respect to some of the elements that are necessary for a TRO, basically, regarding the likelihood of success, the petition focused basically on what occurred at the steward hearings. And the steward hearings, they were provided a full opportunity to present their case, to question witnesses, to challenge evidence. So they were provided the full opportunity for due process at those summary suspension hearings. And in fact, Judge, as Ms. Valencia pointed out, two of the individuals, the Board of Stewards decided to keep them summarily suspended. With respect to trainer Valerio, the commission did lift that summary suspension. So I would respectfully submit that that is evidence that the Board of Stewards and the Commission basically is acting reasonably, responsibly, keeping the protection of the horses in mind, and most importantly, in compliance with your order when in fact it is factually possible to do so. Again, with respect to the 6 horses that Mr. Valeriano was hoping to run in the All-American Futurity trials, lifting the summary suspension simply will not allow him the opportunity to run because, of course, those entries have long ago closed and the fields have set, and in fact, those trials are running as we speak. Addressing another element, the irreparable harm. Again, Judge, simply entering into a race does not guarantee that, in fact, that horse is going to run. It could be scratched by the trainer. It could injure itself on the way to the starting gate. It could rear up in the starting gate such that the stewards feel we're concerned about that horse and we're going to scratch it to keep it safe from itself and possibly keep it safe from other horses. So again, it's sheer speculation that simply being allowed to enter means that somehow you're going to hit that finish line and end up having a purse awarded. Finally, basically, there was an argument made in the petition about that this would not impact the public. In fact, it might be to the public's benefit because it allows more competition in those races. And Judge, with all due respect, the public is already looking at those programs for today and tomorrow, and the wagers are already looking at those horses, determining the odds. So essentially, to upend these trials that have been set, it really does a disservice not only to the public and the fans and the wagerers, but also to the other licensees who basically were able to successfully enter the All-American Futurity trials. Why? Because their license was in good standing, the horse was eligible to enter, they started that entry while that entry period was open, and either it finished while that entry period was open, or the entry period was held open to allow them a reasonable period of time to cure anything that might have been preventing those horses from being entered. So clearly, Judge, if the extreme measure is taken to basically force these horses to be allowed to enter and then either create a whole new race or fit them in available slots if other horses have been entered, it really does deceive the public, and it is a real detriment to so many of the trainers and owners who operate cleanly, who keep their licenses in good standing, and who were there properly entering during the available time to do so. So for all those reasons, Judge, we would respectfully submit that the petitioners have failed to meet their burden on this request, and these are extreme measures that they are requesting, and that the commission feels it just does not have that authority to take those extreme measures with the track and the racing office. For all those reasons, we respectfully request that you deny this second request for a TRO regarding the All-American Futurity races. Thank you, Judge.
All right, thank you. Ms. Valencia, your reply?
Your Honor, if I can just have a moment to discuss with my client.
Sure.
Thank you. Your Honor, our only response would be that to argue back against what Mr. Bustamante has said is that in the court not finding in our favor and not granting us the order, the horses could still be scratched as stated by Mr. Bustamante. If that happens, at least it would be, we would have been given the opportunity to enter. And if we're not allowed to enter, then we, in essence, are being robbed of that opportunity. So we would at least like the opportunity, the order to be granted, to be given the opportunity to not. And then the commission or whoever can decide whatever needs to happen next.
So I guess I should go back to the original granting of the first restraining order and kind of explain again what my thought process behind all of that was. And I will say, Mr. Bustamante, I think that I have a much narrower reading of Bolin than you do. I'm going to paragraph 38 of the Bolin opinion related to quasi-judicial immunity. This is Bolin versus New Mexico Racing Commission 2025 NMRC 34, starting in paragraph 38. And it talks about when does an executive branch qualify for quasi-judicial immunity. And they said there's two factors to consider. It says whether, number one, whether the adjudicatory proceeding shares enough characteristics of the judicial process to warrant the extension of judicial immunity to the proceeding, and two, whether the conduct at issue consists of a judicial function. And so what I think it goes on, next sentence after that, is we also emphasize that judicial immunity should extend no further than necessary to achieve the policy goals of protecting independent decision-making and ensuring the integrity of an established adjudicatory process. And so I read the Hernandez case, I read the Bolin case, I read other cases, and what my ultimate conclusion is that preventing entry and participation in a race without due process is actionable both under the Mexico Civil Rights Act and under Rule 66 would also give me the authority to enjoin the commission from doing that, because it falls outside the Rule 75 issues that we're going to talk about here shortly. So I think that the steward and the commissions are entitled to quasi-judicial immunity for decisions that are consistent with the actual process of adjudicating someone and making the decision, number one, to suspend, and then the due process decision whether that suspension is going to go until the final adjudicatory hearing. Obviously, the impact of a summary suspension without any sort of due process on July 30th, which at that time I thought, based on the initial petition, was not only just the entry, but also I thought the races were the next day based on what I read in the petition. Those are, regardless of what's going to happen at the outcome of the summary suspension proceedings, those are fatal for all of those horses in that series. And that's what I was trying to prevent. Obviously, I was not trying to interfere or alter the suspension. I wasn't trying to interfere with the adjudicatory process through the administrative code that happens first through the stewards and then the appeal through the commission. That wasn't my intention, and that I was only trying to say the entry and participation in the initial trials until a due process hearing basically can happen needs to occur, because if, as we learned in Mr. Valerio's case, sometimes those summary suspensions are lifted. We saw two of his horses get scratched, and he doesn't get to go back and race those horses again. And it appears that they were scratched for no reason since the summary suspension was lifted against him. But ultimately, I think what applies in this case is the rationale that was described in Hernandez versus the New Mexico Racing Commission. And I recognize it's not a published opinion, but I think that it's got a lot of good guidance for the court. This is a 2023 case out of the Court of Appeals. It's case number A-1-CA-39606, filed on July the 20th of 2023, appeal out of Bernalillo County. And essentially the facts were very similar. This is why I almost didn't enter the TRO the first day. I want to make clear that I understand, at least as I understand it, is that so far the only proceedings that have occurred so far are those that are outlined in 15-2-1-9 3, summary suspension, subsections A and B. And if the stewards determine that a licensee's actions constitute an immediate danger to the public health, safety, integrity, or welfare of the horse racing industry, the stewards may summarily suspend the license pending a hearing. And then subsection B, a licensee whose license has been summarily suspended is entitled to a hearing on the summary suspension not later than the 10th day after the license was summarily suspended. And then subsection C, the sole issue, whether the licensee's license should remain suspended pending a final disciplinary hearing. And that disciplinary hearing has not occurred, which means there's not a final order from the stewards, nor is there a final order from the commission from any appeal, because there hasn't been an issue by the stewards. I will say, Mr. Bustamante, if the commission doesn't want to run into a problem in the future, I think Berry versus Barkey, the U.S. Supreme Court case that I talked about last time, 443 U.S. 55, I think there's still a limit, even though you've done this due process one, and that the adjudicatory process when you've summarily suspended someone does require full hearing with a reasonable time. What that is, I'm not going to give you direction of, but you all need to move forward with the actual hearing, full hearing, adjudicatory hearing, if you want to be in compliance with constitutional due process principles that have been in place since at least the late 1970s in the U.S. Supreme Court, which I think New Mexico is bound to follow as well under the 14th Amendment. I'm not commenting as to when that has to happen or how that's going to be, because that'd just be an advisory opinion, but obviously there's clear rights that are involved. What Hernandez says and why this is important. So there was an administrative ruling in that case, and this is paragraph 4 of the opinion, and it says, following the denial of the stay. So essentially what happens is the trainer in that one gets fined, doesn't pay the fines, gets suspended, appeals that to or asks us for a stay of the suspension to the executive director. Executive director denied that, files a petition in district court for a TRO under Rule 1-66. District court dismisses the petition on a failure to exhaust administrative remedies. The Court of Appeals decides it on a completely different issue. It has to do with finality of order, and so they don't really deal with the exhaustion. I think the exhaustion issue would exist if you don't exhaust your administrative remedies, the district court's going to lack subject matter jurisdiction. But they didn't get to that part. They ruled under different grounds. When you look at the opinion, they recognize, as petitioner has pointed out, that injunctions are obviously claims within the district court's original jurisdiction. That's what they say in paragraph 7, and certainly the district courts have the ability to issue injunctions in certain circumstances. And I feel like because there was a violation of due process at the initial part of the summary suspension without due process that was going to impact regardless of what happened at that hearing, I was okay to enjoin initially. But now that there's been a due process hearing, I think it now falls within the jurisdiction under Rule 75. And what you get in the Hernandez opinion, this is paragraph 9 of that. It says Rule 75 specifically contemplates review by the district court of such administrative denial of a stay request, which is the denial of the stay request in this case related to pending the determination by the commission. It says rules, further in the paragraph, it says Rule 75 thus more specifically addresses the administrative origin of petitioner's action in the district court than Rule 66. As a general rule, when two statutes deal with the same subject, one general, one specific, the specific statute applies. Obviously, we're dealing with rules, but they applied that same principle. And it says, because Rule 1-75 more specifically addresses the administrative origin of petitioner's action in the district court, and in the absence of any argument from the petitioner addressing Rule 75, we conclude that Rule 75 may place restrictions on the time of exercising the right to seek injunction of an administrative decision where the injunction amounts to an appeal of a previous denial of such injunction by an administrative official. It talks about Rule 75Q and the timing of that and the restrictions, and ultimately says that in paragraph 12, lacking a final order, the district court properly dismissed the petition. And this paragraph 13, this determination furthers the purpose behind the principle of finality, the prevention of piecemeal appeals, and the promotion of judicial economy. were we to allow petitioner to seek a stay out of the enforcement of the steward's initial ruling in the district court before the commission issued its final order, petitioner could conceivably seek a second stay from the district court, this time the commission's final order pursuant to Rule 75Q. The district court might be obliged to decide two separate stay petitions relating to the same underlying conduct, and then they outline how there are different standards that apply. And so paragraph 15, or actually paragraph 16, recognizes perhaps the injustice that occurs when this happens. It says, we're sympathetic to petitioner's situation awaiting the commission to rule on his administrative appeal some years after filing, but unable to use his license in the meantime. They talk about potential remedies that are there for someone who was waiting for the commission to actually move, and they're not moving, including petitions for writ of mandamus. But ultimately, what Hernandez stands for is that Rule 1-66 does not apply in this case. I would need to go under Rule 75. And under Rule 75, since there's not a final order, I do not have the authority at this time to enter any sort of injunctive relief requested. And so the petition will be denied and dismissed. Obviously, the commission will prepare the order, and then Ms. Valencia, your client, has a right to appeal this decision to the New Mexico Court of Appeals so that they can weigh in on that issue. I will just say this, I think that it's frustrating from an outsider's perspective to have an issue that started in 2024, to wait on the eve of the biggest trials of the races for these horses to enter a summary suspension. It looks suspect, whether it was intentional, unintentional, whether it was because you got a directive from the governor to be harder on people, which is basically what's kind of alluded to in the responses to the ex parte communication that I received. That's not how this is supposed to work. And the question is whether or not I have the authority to do anything about it. I don't think I do. I don't like how this played out. I don't like that Mr. Valerio lost two horses that were able they were scratched from racing because he got summarily suspended without any due process hearing. And then when he finally had that due process hearing, they lifted that summary suspension. It just doesn't seem fair to me. I think that the commission could have moved faster through their stewards to make this process and avoid all of this headache. I don't know that I've had a case that has been this fast and furious in 2 days' time of the number of pleadings I've had to read and respond to and try to prepare for. But it's not meant to be this way. It's not supposed to be rushed like this. And I think there could have been processes to do it. I don't know whether or not Bolin versus New Mexico will apply to all of the things that happened. It's not my issue. It's not for me to decide, other than for the show cause order, which I'm still going to contemplate entering because I do have issues with how my original order I don't think was complied with to the letter of the law, and so there might be sanctions. How the commission can purge those or what those sanctions are will be determined at the next as we finish this next hearing. So Mr. Bustamante prepare an order denying that, and obviously there's nothing restricting at this time the commission or the stewards related to any of the races. The only TRO that's been entered in this case that allowed for the participation was only because it was based on participation happening that weekend. It didn't happen that weekend. If the owner's still been summarily suspended and he gets scratched the races, there's nothing that I can do to prevent that from the 5 horses that were actually entered correctly pursuant to the order. So let's move on to the order to show cause. Ms. Valencia, who are you going to be calling as witnesses today?
Your Honor, one moment if I can just review my notes. Also, Your Honor, can I have a 5-minute recess? I just need to grab something to drink. I'm not feeling well at the moment.
Yeah, that's fine. We'll take a
Yes,
5-minute free.
Thank you so much.
All right. We ready to go, Ms. Valencia, Mr. Bustamante?
Yes,
Yes, Your
sir.
Honor. Thank you. I appreciate it.
No problem. Let me put us back on the record. You got too many windows open. I apologize. I gotta get straight with the case. All right, back on the record on Lincoln County Cause CV 2026-191. We're on the order show cause now, Ms. Valencia. Who are you going to be calling as a witness? And I'm just trying to identify them so I can is anybody invoking the rule of exclusion?
Judge, we will invoke the rule. Thank you.
All right, then I'll need to put the witnesses who are non-parties in a breakout session. So, Ms. Valencia, do you have any witnesses other than the parties that you're anticipating calling that I need to put in a breakout session?
No, Your Honor.
Mr. Bustamante, witnesses other than one representative, you can identify one representative for the commission under the rule of exclusion who can remain, but others would need to be.
Okay. Judge, as I advised the court earlier, the witnesses that we plan on calling are Executive Director Ismael Trejo. He is in the office with me. He's actually in his own office, but if I understand you correctly, he can sit with me. The other witness is Presiding Steward Violet Pinky Smith, and I made a request along with that notice earlier for the court's permission for telephonic, given that she's actually overseeing the trials that are being run right now.
Let me give you the phone number.
All right, thank you.
It's 515-207-5928, and then she'll have to enter a PIN, and the PIN number is 891-022-326#. Unless you're young, it's a hashtag.
Okay, all right. Okay, and that PIN was 891-022-326#.
Yes, sir.
All right. Thank you, Judge.
And I'm just trying to see, so you're designating Mr. Trejo as your representative of the Racing Commission?
Correct, sir.
And I'm not seeing any of your other witnesses currently on, are you?
Director Trejo was on.
I see the Director Trejo. He is present. I'm not seeing anybody else.
Our other witness, Presiding Steward Smith, she is busy overseeing the trials. And once we're ready for her testimony, sir, I will have to reach out to her and then have her call you. Director Trejo is standing right here, sir, as we speak.
Okay. All right. Then Ms. Valencia, you can call your first witness.
And just to clarify, Director Trejo, it's fine that he sits in my office with me, sir?
Yeah, so Rule 615
Yeah.
Allows a representative of a basically non-person entity, so a corporate entity or a government entity. So there's just got to be a designation of who that representative is going to be under the rule of exclusion, and that person is not going to be excluded from the room.
Okay, all right, thank you.
You've designated him as your representative under the rule, then he is not excluded under the rule of exclusion under 11-615.
All right, thank you, sir.
Your Honor, again, I apologize. I need 5 minutes. I'm not feeling well.
All right. Well, let me just ask you this, Ms. Valencia. Can you hang out for 2 minutes, or you need 5 minutes right now?
I can wait 2 minutes.
All right, so here's my point. Mr. Bustamante?
Yes, sir.
I think the only thing that you could do to purge the contempt would be to comply with my original order if I find your entity in contempt. I think you're telling me it's too late to do that.
Respectfully, Judge, it is too late to do that.
So any contempt sanction I issue, you're not going to seek to purge anyways. You're just going to have to be stuck with the contempt sanction.
Well, Judge, we are between a rock and a hard place in the sense of, for all the reasons I've stated and fortunately have stated several times over the last few days, it basically, the commission does not believe it has the authority to order either the track or the racing office or both to basically, allow those entries and then somehow figure out how
No, I
they're
understand that, but I'm just asking a very simple and direct question. You don't believe that you could purge yourself from the contempt if I find that your agents acted and disregarded my order? You don't believe you could purge yourself from that contempt anyway, so you would just be stuck with whatever sanction. You would agree.
You know, it does appear that way, Judge, because again, unfortunately, this all started off with the misstatements in the original TRO, which of course carried over into the draft order, which the judge signed. But yes, Judge, I have been racking my brain and speaking with Director Trejo about whether we could cure this incident. And again, Judge, as the evidence will show, this was not willful on the part of the commission, but
I'm not ruling on that. What I'm trying to get at is this: if Ms. Valencia is feeling ill, I might continue the show cause hearing.
Yeah. Because
the only way I would move forward today is to give you the opportunity to purge yourself of the contempt. But what you're telling me is you can't purge yourself. I'm not saying I'm finding you in contempt.
Yeah.
But if I do, the only reason to proceed today is to give you that opportunity. And if you're conceding you can't purge yourself of the contempt, then you're stuck with whatever sanction if I find you in contempt. I'm not saying I'm going to do it. And so the point of moving forward today doesn't seem to exist.
Right. And Judge, again, I have been thinking about it ever since yesterday, ever since the application for contempt was filed. Director and I have, Trejo and I have spoken several times about it. And we just, given one, the limits of the commission's authority, to the fact that so much, pretty much all of the matters here that are of concern are individual business decisions by these private businesses, and as I mentioned earlier, where the commission does not get involved in, does not regulate, because it feels that its authority does not extend that far. And third, given the timing, I mean, the first part of the trials are happening today. The second part of the trials complete tomorrow. So it's just the reality, Judge, of physics and time, and limits on our authority, and the fact that those tracks are private businesses who can and do make business decisions, which we believe entries and setting of races, specific fields and things of that nature are in fact specific business decisions, which the commission does not regulate. So
give me a yes or no only on this next question.
Yes, sir.
Do you agree that the commission is either unable or unwilling that if I did find them in contempt, to purge themselves of the contempt by adding those horses to the entries?
And the answer is yes, Judge. We are unable.
All right. And if the answer is yes, then what? I don't know that there's a purpose of us staying when Miss Valencia is feeling ill, and I'd rather her feel well and not be something that interferes with the show cause hearing. So what I'll do is postpone the show cause hearing since Miss Valencia is not feeling well. The reality is I don't have a problem. My staff is prepared to stay late, but if Miss Valencia is not feeling well, we're gonna have to take a lot of breaks. I just don't want to move forward if there's not an opportunity to purge or not a request to purge that contempt. So Miss Valencia, do you want to continue this since you're not feeling well then?
Your Honor, if I can just have 5 minutes, please, then I honestly, I don't know. I'm not feeling well. I need to lay down.
Well, that's why I'm saying I can continue the whole proceeding because all that's left is the show cause.
When would we be able to continue it for? I just don't want to prejudice my client.
Well, your client's not getting on the race regardless because I'm not restraining the commission. So they're going to scratch him. Even if they purged the contempt, they'd scratch him because he's suspended. And I'm not lifting that based on the last ruling that I made. So the question is whether I'm going to give you some attorney fees for having to file the motion for order show cause and whether I'm going to sanction the commission. Those are the only two questions remaining. And I don't know that that's necessarily urgent. If I could put you guys trailing some jury trials that I have coming up. And if those jury trials come up, then we could hear it on those days, but I can't give you like a guaranteed set number of hours We have moved a lot of stuff on our docket to accommodate the last couple of hearings, but I've got a bunch of hearings, including people who are in custody, criminal cases that I can't continue. So I could put you trailing the week of August 17th. Every one of those days I'm supposed to be in a criminal sexual penetration of a minor trial. If that cases come off, then I can hear it on one of those days. Otherwise, we'll get notice out for when we can get the next show cause hearing set. But with respect to your client getting the opportunity, I've denied the emergency request. I'm finding that I don't have the authority under Rule 1-66, that Rule 1-75 is what applies. So I can't enjoin the commission at this point.
I understand, Your Honor. I can't proceed today.
Okay.
If you can please continue the hearing, I'd appreciate it.
What I'll ask if council is just file notices of unavailability on Monday by noon of days, notices of unavailability of days that you're not going to be available. And then Ms. Skinner will try to work with both of you to try a mutually agreeable time to finish the show cause hearing.
Yes, Your Honor. Thank you.
All right. Mr. Bustamante, please prepare orders based on today so that I can get those in. I'd like to get them in on Monday, just so that if the petitioners wish to seek an appeal to the Court of Appeals, they can do so.
Judge, I will have those into you either over this weekend or first thing Monday morning. And thank you so much, Judge. Ms. Valencia, I hope you're feeling better.
Thank you, Mr. Bustamante.
All right. We'll be in recess. Thank you all.
Thank
Thank
you.
you.